A constitution is the fundamental rulebook that creates a government, distributes its power, and defines your rights. And understanding it is the literal master key to figuring out how any state functions.
In this explainer, we're going to systematically break down what this rulebook is, how classical theorists defined it, its essential features, the crucial difference between a constitution and constitutionalism, and a massive landmark case that tested these limits. Then we'll wrap it all up with a structured recap.
So let's dive right into Part 1, the ultimate rulebook or the source code of a state.
Let's start with a plain language foundation before we hit the precise legal terminology. Think of a country like a computer. If the country is the hardware, the Constitution is the underlying operating system. It's the core software that allows all the other programs, which are your ordinary everyday laws, to actually run without crashing the whole system. Just like your smartphone will absolutely refuse to run an app that contradicts its core programming, a state cannot legally enforce any law that contradicts its constitution. It is the absolute, unquestionable baseline of authority.
Now, the precise legal term for this underlying operating system is Grundnorm. This was coined by the highly influential legal philosopher Hans Kelsen, and it translates simply to the basic norm. What this means is that the Constitution is the foundational rule from which every single other law derives its legal validity. So if we restate the rule, no ordinary law can ever override the Grundnorm, and every ordinary law must perfectly conform to it to be valid.
Now that we know what it is conceptually, let's shift to our second section and see how four classical theorists shaped these rules over time.
First, we have to look to antiquity. Aristotle gave us the very first systematic comparative framework. He created this brilliant six-fold scheme dividing systems, like monarchy, aristocracy, and democracy, based entirely on two very practical questions. Who holds the power, and for whose benefit are they ruling? For example, is a single ruler acting for the public good, which makes it a monarchy, or merely for their own selfish interests, which makes it a tyranny? This simple but profound framework literally birthed the entire study of comparative constitutional law.
Fast forward to the 20th century, and we meet K.C. Ware. He provided what is today the standard exam definition of the concept. Ware distinguished between a narrow sense of a constitution, meaning just a single written document, and a wide sense. His wide sense defines it as the whole system of government of a country. This encompasses the entire collection of rules, both written and unwritten, that actually govern how a state operates day to day.
Two other legal giants categorize things a bit differently. James Bryce categorized constitutions based on how easily we can change the rules, giving us the rigid versus flexible classification. A rigid system requires special, really difficult procedures to amend, while a flexible one can be changed just like any normal law. On the flip side, A.V. Dicey focused on enforcement. Dicey stressed that in systems like the United Kingdom, unwritten conventions, which are long-standing political customs, are just as constitutionally binding as strict law, even if a judge in a courtroom won't directly enforce them.
All right, let's move into our third section, features and classifications. We're looking at the actual anatomy of a state now.
Let's see how all this theory builds into the 5 essential features every constitution across the globe shares. Whether you are in a brand new democracy or a centuries-old republic, you need these 5 things. First, supremacy. It must be the source of validity for all other laws. Second, the constitutive function. It literally creates the government organs, the legislature, the executive, and the judiciary, and allocates their powers. Third, it limits government, usually through the separation of powers and guarantees of fundamental human rights. Fourth, it balances stability with adaptability. It has to be solid enough to endure crises, but flexible enough to evolve over time. And fifth, the expressive function. It carries the state's highest political values, which you'll often see declared proudly in a preamble.
So, how do these features actually map across the globe? When we look at form, we have written versus unwritten constitutions. The US and India are written in single master documents, while the UK is unwritten, meaning it's built from historical texts like the Magna Carta, along with conventions and case law. Under amendment, remember Bryce, we have rigid versus flexible. The US is highly rigid, requiring a 2/3 vote in Congress and 3/4 of states to amend it. The UK, however, is completely flexible. They can amend their constitutional rules through the ordinary legislative process. Finally, regarding the distribution of power, we have federal systems where power is shared between local and national governments like the US and India, compared to unitary systems where power is totally centralized in one place, like the UK.
Let's look at a concrete example of how nuanced this gets in practice with India's 1950 constitution. It blends these classifications perfectly. It's written, it is mostly rigid but has some flexible parts, and most importantly, while it is federal, it leans heavily towards centralized power. The precise legal term for this hybrid, given to us again by K.C. Weir, is explicitly quasi-federal. It means a structure that is federal in form, but with a strong unitary bias. Write that term down, because you absolutely must remember it.
This brings us to Section 4, Constitution versus Constitutionalism. Pay very close attention because this is an examiner's absolute favorite trap.
Having a piece of paper, a constitution, is ultimately meaningless if an authoritarian state completely ignores it. That physical document is just the Constitution. Constitutionalism, on the other hand, is the actual, genuine limitation of government power in practice. An authoritarian regime can have the most beautifully written constitution in the world, guaranteeing all sorts of freedoms, but if they don't have the rule of law, independent judicial review, and true accountability, they entirely lack constitutionalism. Let's move to Section 5 and put this exact concept into a real-world crucible, the Keshavananda Bharati case.
Here are the facts. In 1973, the Supreme Court of India convened a historic 13-judge bench. This remains the largest bench in the history of that court and has set the stage for a monumental, high-stakes legal showdown regarding the absolute limits of the government's power.
The core issue they had to decide was simple but incredibly dangerous. Did the government's amendment power under Article 368 of the Indian Constitution mean they could legally rewrite the entire operating system? If a government has the power to amend the Constitution, is there any limit at all? Could they legally vote to erase democracy or abolish human rights just because they followed the technical amendment procedure?
The court held firmly that while the amending power is extremely wide, it is absolutely not unlimited. This holding birthed the famous Basic Structure Doctrine. The rule they laid down is that Parliament cannot alter or destroy the fundamental features, the basic structure of the Constitution. This means concepts like constitutional supremacy, the rule of law, the separation of powers, and federalism are permanently protected. They cannot be legislated away, ever.
Why this matters is profound. It is the absolute clearest illustration of constitutionalism in action. It demonstrates the true constitutionalism means the core fundamental rules of a state actually survive even the government's attempt to legally erase them. It acts as the ultimate boundary line of state power.
All right, we've covered a massive amount of ground today. Let's move to Section 6 for a structured recap so this is completely locked in.
We progressed systematically today to give you a complete foundational understanding. We started with Hans Kelsen's concept of the Grundnorm, proving the Constitution is the ultimate source of all legal validity. We reviewed the classical theorists, Aristotle's focus on who rules and for whose benefit, K.C. Weir's wide definition of the whole system of government, James Bryce's rigid versus flexible metrics, and A.V. Dicey's emphasis on binding unwritten conventions. We then mapped the 5 essential features and classifications across the globe, highlighting that a system like India's is officially termed quasi-federal. We made the vital distinction between just having a physical document and actual constitutionalism, the real-world limitation of power. And finally, we proved that limitation using the 1973 Keshavananda Bharati case, which permanently enshrined the Basic Structure Doctrine.
As you review your notes from today's explainer, I want to leave you with this provocative thought. If true constitutionalism fundamentally requires limiting government power, does a federal system where power is spread out, or a unitary system where power is highly centralized, protect that basic structure better? Next time, we're going to explore the deep mechanics of federal and unitary governments to answer exactly that. Keep analyzing, keep questioning, and I'll see you in the next explainer.